Hi, I'm Cliff Ennico, legal and tax editor for itsyourbiz.com with some thoughts on consulting contracts. So, you've been out of work a while, you've been knocking on doors looking for consulting work, and finally, boom, it happens. A company shakes your hand, they want you to work for them. The only thing is you got to sign their quote-unquote standard form of consulting contract. Do you just roll over, sign this thing? The answer is absolutely not. These are not boilerplate contracts. You must read them carefully before you sign, because sometimes these things contain gotchas that can really prevent you from building the consulting practice that you want to build. Here are some examples. Number one, whenever you look at a consulting contract, look at the payment clause. Every consulting contract needs to be crystal clear on two things: how much you get paid and when you get paid. You don't know how many consulting contracts I see in my law practice where they're very specific about how much you get paid, but then they get loosey-goosey about exactly when payment is due. That's not acceptable. If you sign a contract saying you get paid when the quote-unquote project is finished, close quote, that's a problem, because you and the company may have very differing ideas about when that project is going to be completed. It may be weeks, if not months, before you finally get your money, especially if you're doing any kind of website development for that company. In my experience, websites are never, ever finished. They're always works in progress. There's always little tweaks and scooches that have to be done to get those things finished, and you can find yourself being dragged out and out for weeks before you finally get your money. The contract has to be very, very clear when you get paid, what deliverables have to be submitted on what dates, and then payment is due within 10 days after delivery of your invoice. Do not accept any loosey-goosey language in there. Secondly, watch out for the assignment of rights clause. This is in every consulting contract. It says that whatever work product you produce for that company belongs to them. They own all of the rights to it once it's done. And that's only fair. After all, they are paying you for it. But be careful. Some of these clauses are a little overly broadly written. You may have some tools that you use to develop things for people. You may have some software tools, let's say, if you're a website developer. And these are things that belong to you. You develop them yourself. You use them for your other clients. You do not want this company having rights in those things. Make very sure the assignment of rights clause specifically excludes things that you have written, things you have done that belong to you by right. Otherwise, they won't be. Otherwise, you're handing over ownership of those things to your client, and you will not be able to use those for another client. Next, look for disclaimers of warranty. These will probably not be in the contract. You will need to add them. A disclaimer of warranty basically says, look, I guarantee that my work will be done in a professional manner, but I'm not going to guarantee that you are going to be happy or that you will achieve any specific result, even if you tell me that this is what you want to do. I don't guarantee results, because let's face it, none of us can. All we can guarantee is that, as professionals, is that we will do our work in the best possible quality, but we cannot guarantee that the customer will be happy. That clause needs to be in there. There's very specific language. Your attorney can put it in for you, and if it's done right, the client shouldn't balk at it too much. Last but not least, you should consider putting in a limitation of liability clause. This is a clause that says, even if I do foul up, if I make a mistake, all I got to do is give you your money back that you've paid me up to that point, and I'm off the hook. You can't sue me. You can't take my car away. You can't repo my house or my kids or anything like that. That's it. All I got to do is give you your money back, and I'm off the hook. That will not be in your standard form of company consulting contract, but it's something you should negotiate in, just in case, God forbid, something does happen. You want to make sure that you can get out without being sued for $10 million. I can't stress this more enough. Make sure you have a consulting contract reviewed by an attorney. After you've done a few of them yourself, you probably can negotiate them yourself. But for the first couple, have an attorney look at it. Most of them will not spend more than an hour looking at these and giving you comments, and it's money that is absolutely well spent and fully tax deductible. I'm Cliff Ennico for itsyourbiz.com.